Hello, and welcome to day one of the Federal Bar Association's annual Employment Law Program. I'm Brenda Feiss. I'm a member of the Federal Bar Association's Board of Directors and chair of our Employment Law Committee. We have a great program today. This is our second year doing this time-honored program remotely, and we really miss being able to see each other and mingle. So we really appreciate your being here today from wherever you are. I know you're going to really enjoy what we're offering. Before we get started, I'd just like to take a moment to encourage you to become a member of the FBA's Chicago chapter. There's so many benefits to being part of the FBA. As with today's, or actually the next 2 days programming, you'll see that our federal judges participate in many of our programs. Our chapter is particularly distinguished by the high level of involvement of our federal bench. So membership in the FBA is really a great way to get better acquainted with our local federal judges. We offer many high quality programs on a variety of topics relevant to federal practitioners. So I would strongly encourage you to consider joining our Chicago chapter. You can sign up on our website at www.fedbarchicago.org/membership. For those of you who didn't write it down, you can easily find it on the web. Before we start, I must make a few thank yous to Lisa Jackson, Lily Silva, Beth Eckel, and all of our terrific moderators for all of their help in coordinating this program. We couldn't do it without you, so a big thank you. Some final tech notes for all of you in the audience. This program will be recorded, so if you want CLE credit, you must watch it within 2 months. We have some great materials and bios for all of our speakers. Those can be downloaded from this platform, but you must do it before the program ends. So thanks for being here, and I will now turn it over to our first program.
Brenda, thank you for the introduction, and I want to thank everybody for attending today. As Brenda indicated, we had hoped we would be back in person this year, but unfortunately we find ourselves in this environment, which is the focus of our discussion today. If you are a repeat attendee, you got to meet Peter and Carol a year ago, who spoke on this same topic. I think a year ago, we were just starting to implement vaccines. I think in January, they were primarily available only to the elderly and immunocompromised. And here we are now in the land of boosters. We now have the Supreme Court involved. We now have the Omicron surge. So we find ourselves still pretty steeped in all of the issues around COVID. We also find ourselves, I think, presented with even trickier questions than ever in this world. And so I know I have a lot of questions, and I'm excited to talk to my panelists today. If you have questions, please feel free to send them. We will try to get to them during the course of the program. We'll also try to reserve a few minutes at the end. I can't promise we'll get to everybody, but we'll do our best to be responsive to questions as they come in. I'm going to very quickly introduce the panelists here because I'd like to get into it, and we don't have just but an hour here. So I'm going to first introduce Peter Vassallo. He is, and I'm going to do this very briefly, their extended bios are much more comprehensive and impressive than I can spend time on here this afternoon. But Peter is the counsel for special litigation at the Division of Occupational Safety and Health. And in this role, Peter focuses on enforcement-related matters, including OSHA's COVID enforcement efforts. And he is the point person with respect to OSHA's process safety management standard and enforcement related to that standard. Carol Miaskoff, and I hope I got that correct. Perfect. She has spent probably more than 25 years in the Office of Legal Counsel at the EEOC. She was serving in the interim role at this time last year, but has since been appointed legal counsel. So she's in the chief job in the legal counsel office at the EEOC, and in that role, she manages the development of the Commission's regulations and guidance, which we will be talking about today. Mike Schmidt is the co-vice chair of Cozen O'Connor's Labor and Employment Department. So he's actually my colleague and my co-vice chair. He's the office managing partner of Cozen O'Connor's New York office. He has been one of the leaders in Cozen O'Connor's coronavirus task force. So from the very get-go, Mike has been involved in helping employers manage their way through these uncharted territories. He's also the voice behind the Employment Law Now podcast. If you haven't listened to it, you must. It's a must listen. You can find it on Spotify and iTunes and our website, Cozen O'Connor's website. So, and I'm sure there's other locations that Mike would love to tell you about. I think we're going to start, Peter, with you today. On Friday, the Supreme Court heard argument over the ETS, the OSHA's Emergency Temporary Standard, on the what I think has colloquially become known as the shot or test rule. This is probably the broadest applicable issue coming out of your agency. So can you just tell us where things stand on that mandate and any other mandates coming out of your office?
Absolutely. So let me first just say that in terms of the case, the argument, we're waiting just like everybody else to get a decision. We don't know when that's going to come, but we're expecting that to happen soon. In terms of our standards, I wouldn't call them mandates. There are our standards and that we've promulgated under our emergency temporary standard authority. Let me tell you a little bit about where we are with the two of them. As everybody probably knows, OSHA promulgated 6 months ago an emergency temporary standard focused on the healthcare industry. We were not sued over that, and it did go into effect. So let me tell you a little bit about where we are with that right now. So on December 27th, OSHA announced that it is going to be withdrawing its healthcare ETS with the exception of the record-keeping requirements within the standard, which are going to remain in place under a separate provision of the Act. OSHA is going to continue to work expeditiously towards a permanent standard that will protect healthcare care workers from COVID-19 hazards. With the rise of both the Delta and Omicron variants, both this fall and the winter, OSHA continues to believe that the danger faced by healthcare workers is a very high concern. And we do need measures to prevent the spread of COVID-19 to protect them. Even though the healthcare ETS is not in effect anymore, we strongly encourage employers to continue following the provisions of this. It's the simplest, easiest, and most straightforward way for employers to comply with their OSHA Act obligations. However, as we work towards a permanent regulatory solution, whatever that's going to be, employers still have obligations under the OSHA Act, similar to what we did before we had the healthcare ETS. And that includes under our general duty clause, Section 5A1 of the Act, which requires employers to provide a safe and healthful workplace free of recognized hazards to their employees. We also have our personal protective equipment, PPE standards, and probably most importantly, our respiratory protection standard, which require, after the conclusion of a hazard assessment, that employers are fitted with and provided respirators to continue to wear, which would be a very important thing to do. We are going to continue to vigorously enforce these requirements. I can tell you that OSHA will accept compliance with the terms of the healthcare ETS going forward as satisfying employers' related obligation under the general duty clause, respiratory protection, and PPE standards. So in other words, if you are already a healthcare employer and you're already complying with the healthcare ETS, even if it is in effect, if you're continuing to do that, you're still going to be okay. We will consider you to be in compliance with aspects of that. So that's where we are with respect to healthcare.
Yeah, and just a quick question. So the agency is working on a permanent solution then for that industry, is that right?
It is under active discussion and working on trying to figure out the best way to accomplish that. Yes, correct.
And the permanent solution would have to go through the notice and comment period then?
If we issue a final rule, a permanent standard, that yes, it would have to go through our typical regulatory process. That's correct.
Thank you.
Yeah. Okay, so turning to the vaccine and testing emergency temporary standard. Okay, so this was what was argued in the court on Friday. So as we all know, it's a critical moment for the nation's health, especially as the U.S. faces this highly transmissible Omicron variant, and it's critical to protect workers with vaccination requirements and testing protocols urgently needed. And the vax and testing rule ensures that employers are protecting their employees. We were very gratified that the U.S. Court of Appeals for the Sixth Circuit dissolved the stay of the vax and testing ETS and allowed it to go into effect. And OSHA can now implement this vital workplace health standard, which will protect the health of workers by mitigating the spread of this virus in the workplace. As we all know, soon after the stay was lifted, the parties filed appeal with the U.S. Supreme Court. You know, as I would have to say, that we're confident for the legal authority for the ETS, and as you know, that we have vigorously defended it in the court. Although many organizations have already come into compliance with this, if you have not, it's time to move forward pending on what happens with the Supreme Court. Now, we understand that there is some uncertainty right now. We're waiting for the ruling. We don't know what's going to happen. So OSHA is going to be exercising, if it comes into effect, some enforcement discretion with respect to the compliance dates of the ETS. And this is if the court rules in our favor. So to provide employers with sufficient time for compliance, starting today, we weren't going to issue any citations until starting today because, you know, we had the holidays and so forth. And we will not issue citations for noncompliance with the standards testing requirements before February 9th, so long as an employer is exercising reasonable good faith efforts to come into compliance with the standard. I know your next question is probably going to be, what are reasonable good faith compliance? I think what the answer to that really is that if you are doing your best, you're working on it, you're trying to get a program implemented, there's something down on paper, I think the agency will likely, and I can't speak, you know, specifically about this, but you'll get some latitude in terms of that. I think the people that are going to be probably facing more aggressive enforcement action will be employers that just refuse to do anything and make it clear that that's not what they're going to do. OSHA is, throughout all of this, will continue to work closely with the regulated community to provide compliance assistance. Now, I'm sure one of your questions is going to be, what happens if the Supreme Court throws the rule out? I don't have an answer for that at this point. You know, we certainly have other tools in the toolbox that we'll be able to use, but in terms of what the steps forward are, I don't know. We're just operating right now under the assumption that we do not have a stay in effect. The rule is enforced right now, and pending on what the court does with it, you know, we're moving onward. So that is the current status of the vax test ETS.
So Peter, I have a couple quick questions follow up to that. So on Friday evening in Illinois, our governor indicated that they were implementing basically OSHA's ETS standard in Illinois, although the timeline is a little bit different. So can you explain to us what the state plan administrator sort of role is here, and is this required of the states who serve in that capacity to follow along with the department's ETS?
Right, that's a good question. So so state plans, no, Illinois is a public sector state plan. We don't cover private employees in the state of Illinois. We do, the state of Illinois doesn't, I should say that, it's the public sector. State plans are required under the authority of Section 18 of the OSHA Act to be at least as effective as the federal OSHA. So what that means is that if we have a similar standard, the state plans are required to put something similar in effect that's at least as effective. So that's the move that you're seeing from the state of Illinois in terms of public sector employees. Now, state plans certainly can go beyond what OSHA requirements are. So even if we lose in the Supreme Court, if you have a state plan that wishes to have a vaccination and testing rule under their state legal authority, they should be able to probably do something like that. But that's up to the states to decide that. That is not something that would be coming from Fed OSHA.
Thank you. And Mike, I'm going to come back to you on that state question in a minute, because I know that was certainly a significant argument made by the challenge to the federal OSHA standard. So I'd like to come back to that in a minute, but let me just ask you this question, Peter. So you say that okay, the standard is still in place as of today.
Right.
Yep, and obligations are sort of in place as of today, and you indicated that the agency wouldn't really start any issuing any citations until early February. How would non-compliance come to your attention at the agency? Are you doing like spot checking audits, or is this complaint driven? How does it come to your attention?
So that's a really good question. So we are working on, and there will be a kind of a more down the road specific kind of program about how inspections are targeted and so forth. How it comes to our attention now is really primarily through complaints and referrals. So if we get a formal or informal complaint in one of our area offices, you know, we would do some sort of an initial investigation. Might not necessarily mean that a compliance officer gets sent out to the site. Might be a phone call, might be you know, some different engagement that we're going to have. But that's at the outset. That's primarily how we're going to hear about you know, non-compliance in workplaces, and we are getting complaints from employees nationwide.
Okay, understood.
Mm-hmm.
And sort of related to that, has the agency, you know, you mentioned the general duty clause and the PPE standards that are already in place. Has the agency, and maybe more so in the healthcare sector, but have you been doing investigations under those for COVID related issues under those standards that are already in place?
Oh yeah, absolutely. Well, now for the last 6 months, obviously anything that we've been doing has been under the healthcare ETS, because that's been a specific standard that's been enforced. Prior to the healthcare ETS, however, we did several hundred, at least that I know of, and maybe even more. I don't have the specific data pull from OSHA to give you those numbers, but I know for a fact, particularly focused on OSHA Region 2 in New York, the New York, New Jersey, their jurisdiction, they did several hundred inspections of healthcare facilities, and there were general duty clause citations issued. There have been general duty clause citations issued, both within healthcare and outside of the healthcare areas. And we've issued a number of respirator violations to employers, particularly in healthcare. And those include things like failing to have a program, failure to do fit testing. Those have been kind of the general sort of things that we've looked at. Failure to do a medical evaluation of employees about whether or not they could wear a respirator. That's been kind of the primary focus of where those citations were prior to the healthcare ETS coming out.
Perfect, thank you. So Mike, I am going to turn to you for a minute, because I think you might have something to say that maybe Peter's restricted in saying, but so let me just, you know, I'll just start with, you know, the arguments on Friday, and which I know you listened to, And also, just as we're at January 10th, what have you been doing based on all of the developments that you've been seeing to get employers ready to manage the situation as it exists right now?
Yeah, it's been fascinating, and if you listen to the arguments on Friday at the Supreme Court, and it's so great that they make that available and through a live stream, it really was so interesting because you're not just talking about technical issues and technical rules, but really policy and things that apply to all of us as humans. I mean, we all are either employers or employees. So these issues that we're talking about and that the Supreme Court was grappling with really apply to everybody. And I think the majority of the Supreme Court, and we'll see where they come out, but they were certainly concerned primarily about both the scope of the rule itself, as well as the scope of federal authority to implement this kind of standard or this kind of rule that the ETS is trying to implement. And, you know, the state and the local mandates that have come out in the last several months, going back to a good chunk of 2021, have had far more success in withstanding challenges to them, whether to the exemptions, the lack of exemptions, or just to their ability to implement the rules and mandates on a state and local level. That has primarily been because it's much more accepted that state and local governments have that ability to regulate safety and health. And that's really the question. Does the federal government, particularly doing it the way this agency has tried to do it, does the federal government have that same ability to regulate broadly health and safety? So the arguments were fascinating. If you were on Twitter over the weekend, there was a lot of, you know, sort of betting of the over-under. When are we going to get a decision? So many people thought it would be before today's first deadline. But here we are, and we expect to hear something soon, but it's an open question when that will be.
So Mike, you raised some like really terrific points. I know you're in New York, and I know New York has a variety of state and localized mandates. Illinois and Chicago are in kind in that regard, and so Chicago has had vaccine mandates issued for city employees. Those have been challenged, largely upheld. I think the police one is still perhaps in the works, but firefighters and all the other employees subject to the mandate, I think, are stuck with it. And actually, prior to the November ETS, our governor came out indicating that certain types of employees would also have to either be vaccinated or go through periodic testing, although only I think it requires only once per week in our state. But those include teachers, daycare workers, healthcare workers, those types of employees. And just before the end of the year, a federal judge here in Chicago also held up that mandate. So I mean, do you think one of the outcomes here is that even if the ETS from OSHA is not upheld, that we are going to be seeing states really some states at least fill the gap here? And what does that mean for employers who operate in multi-states?
Yeah, no, great question. And we could probably talk for hours about this concept of, you know, 15, 20 years ago, employment law was very much a national, federal area of practice. Some would say it was easier because, you know, like the tax code, you had one or two books of employment laws on a federal level and you had to follow them. Here we are, and whether it's a product of states just becoming much more activist, or whether there's just been general frustration that not a lot gets done on the federal level when it comes to employment issues, you have seen the past 5, 6, 7 years, state and local entities becoming much more active across the board on employment law issues, whether it's paid leave, family leave, restrictive covenant issues, and certainly these types of public health and safety issues, wage and hour, to name another one. So within that context, I think there's no question that because of a lot of the uncertainty, the back and forth from the federal side, you are seeing a lot of state and local governments getting into the arena on this vaccine mandate issue. And I do think you will continue to see that. You know, state and local governments are able to enact rules and standards that are, you know, meeting the minimum standards that the ETS has, if the ETS continues to be in effect. But to your question, I absolutely think that the states, you're going to see a lot more involvement on this issue. And what that means, it's a challenge for those employers who are multi-jurisdictional. So if you've got operations, you have employees in many states, and this whole COVID-19 has really made it even more challenging because of the remote work. So you may have been a company in one state, but now that you're having your employees work remotely, they're in many different states that you didn't initially intend to operate business within. So it's imperative that you figure out and stay abreast of everything that's happening, everything that's changing in those different jurisdictions.
So relatedly, Mike, I think, when we look at localized vaccine mandates, or even, the OSHA standard that's in effect, but we look at state laws around things like the compensability of certain activities. Like in Illinois, for example, our Wage Payment and Collection Act requires employers to reimburse employees for necessary expenses. So how do employers approach these issues around who pays for the time spent getting vaccinated, who pays for the test itself, who pays for the time spent getting periodic testing if you're not vaccinated? Those types of issues, how are you approaching those with your national employers?
Well, the compensability and the wage and hour issue is definitely a sore spot when it comes to employers, because the OSHA ETS, again, even assuming that it remains in effect, it doesn't speak to the compensability of the testing costs itself. It talks about employer support for things like taking time off to go get vaccinated, or specific leave that employees may be entitled to if they have certain side effects of the vaccine. But the OSHA FAQs specifically say, hey, for issues like testing costs and reimbursement, you need to look at state and local laws. You need to look at collective bargaining agreements and see what those say in order to figure out what the obligation is. So, same answer as I just gave. You have to look at the patchwork of state requirements. As you said, Illinois is one. California has a significant expense reimbursement statutory scheme. So you need to figure out, one, where are you doing business? Where are your employees? And then on these issues, particularly those that the OSHA ETS does not speak to, what are the various state laws? And are we as a company going to also have a patchwork of obligations? Or are we going to adopt perhaps the strictest of all of the states that we operate in, so that we can ease the administrative burden a little bit and just have one particular policy for the time being?
Got it. So let me ask you, I want to ask you a little bit about some new mandates that have been coming into place that aren't necessarily employer related, but like, for example, in Chicago just last week, in order to go into certain establishments where you're going to eat, for example, you have to show proof of vaccination. And one of the questions we got from a viewer today is, how are government, entities expected to enforce that? And I'll just give you a couple anecdotes. My daughter and I, she's 18, we went to a neighborhood coffee shop this weekend, and it's tiny, you walk in and you can order at the counter, and you don't have to show anything because presumably you could leave, or you could order at the counter and then go further in, and there was like a barrier set up saying, show us your vaccine card. And we literally could have just walked past it. Like nobody was really asking us to show, we sort of volunteered, but even then it was like, he didn't check it against my ID. It was just like, oh, good, it looks like you're vaccinated, go ahead. So what are municipalities, or states going to be doing to sort of enforce these types of mandates out there?
So, and I don't want to speak for the governments, but I would say that my sense is the governments are not looking to be punitive, and the governments are not looking to necessarily come down hard for the sake of enforcing these. I think at the end of the day, those entities, those government entities that are implementing these mandates or standards, their goal is to get people vaccinated. That's at the end of the day what we're talking about. I think you could say that about the Biden administration back in September when President Biden announced this. Whether all of this was going to be effective, not effective, thrown out, the goal was to get vaccinated. So I think there are three ways that, to your question, the cities and states are going to be enforcing their particular mandates. One is through a fine system, and they will be providing fines. I don't know, and I suspect that that is probably not the biggest deterrent for a lot of companies. It's coming to the second and the third options where I think you're going to see more of the deterrence. The second is going to come through the publicity, that if you are an establishment that is now in the news or otherwise known to be not complying with guidance and with some of these mandates, is that going to be a place where people are going to frequent and go to? So it may not be a direct fine in your pocket, but the publicity, the negative publicity, may be something that incentivizes you to comply. And certainly the third one, which in some respects is also directly affecting your pocket, are the civil lawsuits and the potential exposure that you may have. If you have a coworker or a patron who gets seriously ill by going into your establishment or your workplace, and this is not all necessarily tested yet, and we will likely not see these kinds of cases make new law for some period of time. But if you are shown as a corporation, as a business, to not be complying with best practices or with government mandates, will there be a question of potential civil liability for those who get injured while you are not complying? I think those are the three ways that governments are hoping that their mandates and their goals will be accomplished.
I think too, Mike, that for employers, the question is also around training, like getting their employees trained up to ask these questions and to deal with potentially, unsavory customer experiences. I know my daughter's friend, who's also 18, serves as the host at a restaurant, and she was terrified about last week coming because she's like, what if I ask somebody and they get mad at me? I'm nervous about what to do in that situation. So I think
the communication, the communication and the training, and we say this about a lot of issues also. It's one thing for the C-suite of your larger companies to understand all of this, even your HR people, but it's the front line, those who are in the trenches, whether it's the managers, the supervisors, the maitre d' at a particular restaurant or bar. They're the ones that need to be trained, to your point. They're the ones that need to know the do's, don'ts, and what can we say, what can't we say. At the end of the day, we're just trying to deal with a very novel set of circumstances, a generational situation, the best we can to keep everybody safe and healthy.
Great. So I want to get to Carol, and I want to hear about the ADA and Title VII. I have like one last set of questions for you, Mike, around the two other pieces of federal action that are out there. So one is the Center for Medicare and Medicaid mandate, which was also argued on Friday. What I'm hearing is that that's likely, it sort of trended positively in oral arguments. And then the other is the federal contractor, which seems to be really kind of all over the place. So I'd be curious as to your 1-minute thoughts on those two issues.
I'll give Carol more time and make it even less than 1 minute for you. From the CMS standpoint, you're absolutely right. We're sort of in a little limbo because half of the states have an injunction, half of the states in the country don't. I agree with you that on Friday, without too much reading of the tea leaves, the Supreme Court seemed a little bit more receptive of this more targeted approach to this particular industry when it comes to whether or not to impose a stay in the CMS mandate. So we're waiting for that decision. I also agree with you on the federal contractor side. That really has been all over the place as well, and that has been enjoined too. So we're waiting.
Is that a national injunction, or is it in like some significant number of states?
Yeah, the latter. It's
the
latter.
Okay. So in some states that's still in effect, and then in other states it's been enjoined. The states that sued in the 11th Circuit and 6th Circuit, I think. Is that right?
Yeah, that's my understanding.
Okay, great. Carol, we got a lot to talk about. Your office has obviously been very busy in this past year since you joined us here. Obviously, the agency under your leadership issued the first COVID-19 guidance in early 2020. We've seen that guidance evolve over time, tackle new subjects. as the pandemic has evolved. What's the latest? What's the last word from your office on this guidance?
Okay, well, the latest that we've updated it, I guess, several times over the last few months. On December 14th, we issued a section of our central guidance document, which we call a COVID what you should know, a very basic kind of title. We added section N as in Nancy, which gives you a sense of how far we've come about COVID as a disability. And that was in December. This really, the significance of that section, I think, is that it built on the guidance that the Department of Justice and HHS had put out in a sort of more limited regulatory context regarding long COVID, where they said long COVID is a disability. They did it on that guidance under Section 504 and under the Affordable Care Act. Our guidance is for employers under Title I of the ADA, as well as the Rehabilitation Act, to the extent those cover employment. And we just look at COVID as a disability. And really, you know, as I was thinking about it this morning, you know, the analysis is largely the same. In my view, we basically just look at the situation case by case for anyone who is diagnosed as having COVID and whether they meet the definition of actual disability, which is an impairment that substantially limits major life activity or record of or regarded as. From the DOJ HHS perspective, they sort of started with a smaller lens, that to get in their door, you had to have the diagnosis of long COVID. So we sort of broaden it out. You can have a diagnosis of long COVID, you can have a diagnosis of COVID. The question is going to be, is the impairment, which is COVID, does it substantially limit major life activity? Major life activities in the COVID context typically are neurological systems, cardiopulmonary systems, breathing systems, or the sort of body system, the body operations, the major life activities that are impacted by COVID. And the question really is going to be, does the COVID itself or ongoing consequences of that COVID last for several months or more? And that can either be on a continual basis or it can be on an intermittent basis. And when it's intermittent, it has to be serious when it's active, substantially limiting when it's active. So that is the, how we are looking at it. I think another point that's relevant to sort of the overall discussion is really that only the first two prongs of the definition, disability, actual and record of, entitle someone to a reasonable accommodation. And that's where EEOC comes into the picture, as sort of we're all about the exceptions to vaccination and testing requirements, with the exceptions as mandated by law being under Title VII of the Civil Rights Act for religion and the ADA for disability. And it's really only the first two prongs of the definition that entitle someone to accommodation, not the last prong regarded as having a disability. So that's sort of standing on one foot, our most recent addition. But I do also want to point out that this fall we basically had on a monthly basis new additions. And in November, we put out a piece on retaliation in the workplace for asserting EEO rights, which include EEO rights to exceptions to requirements for the vaccine, testing, masking, et cetera. So we put out the retaliation guidance in November, and shortly before that, we put out a whole sort of separate part of our guidance on religious accommodation in the workplace, where we dove into that topic, both sort of, in a sense, at a general level, because this is what us inside the Beltway people call technical assistance, meaning that we're not taking any new legal positions here. But more importantly, we try to temper that with applying it in the context of the pandemic with real world questions. So that was this fall, and then we also updated some of the ADA accommodation questions and answers then too. So yes, it certainly has been a busy fall. If you like, what I could do now is sort of go through some of the basic standards, the general standards on accommodation, these exceptions to the requirements, and then some of the overall points that we made straight to the ADA, in the ADA context and in the religion context.
That's terrific. I think the participants would love to hear from you on that, Carol.
Okay, great. Okay, so I'm a lover of history, so I will sort of point out that Title VII, since 1972, has included a requirement that employers who are covered by Title VII of the Civil Rights Act of 1964 have to, quote, reasonably accommodate to the sincerely held religious beliefs, practices, or observances of employees or prospective employees, unless they're unable to do so without experiencing an undue hardship, which is a term of art, on the conduct of their operations. So you have to reasonably accommodate, one element, sincerely held religious belief, practice, or observance, unless it imposes an undue hardship. The first guidance that came down was the Supreme Court 5 years later, 1977, in a case that is dated because it involves the airline TWA. Now, who has heard about that for a long time? TWA versus Hardison from 1977. And it said that undue hardship for purposes of Title VII means de minimis cost. Now, I think if you had to take away one thing about religious accommodation, I want it to be that de minimis cost does not mean that any and all accommodations are undue hardship, so you don't have to do any of them. That is not what it means. The term in the statute is undue hardship, which means sort of extra hardship of the way the EEOC is interpreting it. And if you look at the facts in TWA versus Hardison, the court said more than de minimis cost. But what they were looking at was for a situation where TWA would have to make a long-term commitment to pay premium wages, i.e. overtime, for an open-ended period of time to get a substitute for someone for a religious accommodation. And they said that that would be an undue hardship. But that leaves a lot of space here. It leaves space for the administrative costs of rescheduling. It allows, in our view, for infrequent or temporary payment, in a very short term of premium pay. And it allows for accommodation. But it has to be, more than, it has to be undue, more than hardship, but not a very large amount. In practice, undue hardship, that does involve cost, as in TWA, but as a practical matter, it typically involves the impact on operations. How disruptive to the employer's operations is it going to be to grant this accommodation? And as part of that, you can consider how many other people actually have accommodations. And I emphasize actually have because it's not, you cannot consider how many more people you're afraid will ask for them. It can't be speculative, but if you already have a lot of people on accommodation, that plays into the basically the operation of your business and how can you continue conducting it. So that's Title VII. The Americans with Disabilities Act in 1990 picked up this concept of reasonable accommodation and applied it to disability. And it said that for Americans with under the ADA, reasonable accommodations means a modification or an adjustment to a job application process, the work environment or the work policies, or anything else that's necessary to allow an individual with a disability to enjoy full and equal benefits or privileges of employment. So that's reasonable accommodations, or fleshing out the definition under the ADA. And again, the bookend here, the employer defense, is undue hardship. Under the ADA, the statute defines undue hardship as significant difficulty or expense. So just by its terms, that arguably requires more inconvenience for the operation or more cost than Title VII would. As I think I mentioned before when I was talking about disability, when is reasonable accommodation triggered? And that's an important one. It's triggered if someone has an actual disability, an impairment that substantially limits major life activity, a record of a disability, but it is not triggered for someone who is regarded as having a disability. There are no accommodation rights if someone is only regarded as having a disability. And I think really the core piece for purposes of COVID and reasonable accommodation and these vaccine requirements, masking requirements, testing requirements, is reasonable accommodation is triggered. That duty is triggered if an employer has a policy that might exclude someone with a disability, i.e. requiring them to get the vaccine or tested or masked in certain circumstances. And if the employer considers the risk that would be posed by this worker if they didn't comply with the policy, and if that would be a direct threat under the ADA, then the employer has to see if there are any accommodations, any alternatives to the official policy that could be provided as an accommodation that would reduce the level of threat so that it's no longer a significant risk of substantial harm. It's no longer basically very threatening to the individual or others. And to give you a feel for direct threat without reciting a regulatory standard, the EEOC still has taken the position that having someone in the workplace who has COVID would pose a direct threat to other workers. So therefore, the question is going to be, is there an accommodation that can reduce or avoid direct threat? And that will get us into the standard accommodations we're considering and we're all using as employers in this pandemic. Telework, reassignment, and I should add, in terms of accommodation for vaccination requirements when they're imposed, you get in the accommodation here is basically the exception to the policy requiring vaccination. And as part of that exception, an imposition of other practices, which are essentially accommodations also, you could look at them that way, which are testing and masking. So if someone could pose a direct threat if they're not vaccinated, then they can be offered as alternative safety practices, as accommodations, the opportunity to be tested regularly and masked. What we're seeing in practicality is that there are a lot of employees who are, if they object to the vaccine mandate, are also objecting to the testing and masking mandates. And then the question would be, without the testing or masking mandates, can they be in the workplace unvaccinated without posing a direct threat? And that is the answer to that is probably no. You don't have to wait for them to get COVID to come into work until they have COVID. You don't have to wait for that to trigger the direct threat defense. Okay, a few more points, quick points that I will make about accommodation, specifically religion. And that, again, as I said, is section L of our COVID, what you should know. And that's, first of all, how does someone request religious accommodation? They don't have to say any magic words like, accommodation, etc. Title VII, don't have to mention those legalities. However, the core of the request is they have to assert and ultimately be able to explain that there's a conflict between their sincerely held religious belief, practice, or observance and the employer's requirement. This conflict is what has to be accommodated. And a few other questions that come up a lot in the religious context. First of all, do employers have to accept that someone's religious belief is legitimate? They have to accept it at face value, or can they question it? There are two prongs to that. One is the religious nature of the belief. And a religious nature of the belief goes to sort of a system of belief about the sort of the nature of existence, really, and the nature of right or wrong. It does not include economic, political, or personal views. The second prong is whether it's sincerely held, and that basically means whether or not the person's assertion is credible in the big picture. Our general advice to employers is, because of the First Amendment, is definitely safer to stay away from questioning the religious nature of the belief unless it's, a patently absurd belief. Like we actually had one case where someone said their religious belief was to eat cat food. And that, is sort of patently not a system of belief. But in the general case, stay away from questioning the religious nature. However, you can assess credibility.
So Carol, can I jump in, Carol? I do think the religious accommodations have presented some requests, have presented some tricky issues on the sincerely held belief and sort of the factual foundation for asserting, I don't want to find myself in a position where I don't want to be seen as denigrating any particular belief, but there are concerns that seem inconsistent, I think, with sort of other positions that have been sort of in the discourse around particular religions and whether or not putting certain types of materials, quote unquote, into your body and changing your DNA and these things, which can be, the changing of the DNA, which I think is scientifically not accurate. Like that would provide, I'm assuming, a basis to look at the sincerely held belief prong. Is that fair?
Well, the scientific fact, I should say, in my view, goes more to whether it's religious in nature or not, rather than the credibility of the person asserting it. Though you could say credibility, though I think really it's, a lot of, that goes to the consistency. Credibility goes to the consistency of what the person has been saying. That said, people change religious beliefs over time. And so, the fact that someone, was willing to say get a polio vaccine for their child does not necessarily mean that they're insincere in saying they have a religious belief about the COVID vaccine. I think another point to make here is that employers need to look at each person as an individual in terms of their religious belief. So they don't have to get a letter from a pastor or a priest. If someone is a Catholic, for example, we've heard a lot about this, and the Pope has actually come out and said that it's okay to get the vaccine. Nonetheless, if individual Catholics, due to their personal practice of Catholicism, still object to that for the vaccines that are tested using fetal material, then that has to be respected. You can't, we've had instances where employers have said, well, sorry, the Pope said you can, now you must do it.
Yeah,
So not a great idea.
Got it. Carol, thanks. So we have a couple questions coming in just a few minutes left here. So I'm going to turn to these questions, and forgive me, they were not showing up originally for me, but I have them now. So I'm going to finish out one question on accommodation, then I'm going to go back to vaccine mandates for just a minute, or vaccines and employer mandates, I should say. So where is the line? So for example, Carol, if an employee says, I believe that vaccinations have trackers, and that the Gates Foundation or some other entity is going to track me, or the government's going to track me because they've inserted this into my body. Is that something, where does that line get drawn?
Well, the line is basically that under Title VII and, to some degree, the First Amendment, religion is looked at flexibly, broadly, but it has to be a system of belief about the nature of existence. I think the case law is pretty clear that it's not political positions. If something is both, we've had instances where people both assert a religious belief and a political belief, then it is still a religious belief. But in the example you gave, if something can be factually incorrect as just a factual matter, a matter of science, and the person does not otherwise assert any, plausible religious belief, then the employer doesn't have to provide an accommodation. But I really caution, caution employers to bring, I guess, a tone of respect to this. And often that goes very far, regardless of where you ultimately end up, to bring a tone of respect of what is the religious belief, rather than a tone of, well, you're just making up an excuse. I think that's important.
Okay. So we have just 2 minutes left. So I'm going to ask these couple of questions, and to the extent each and every one of you wants to weigh in for 30 seconds each, I'll let you do that. But one of the questions relates to boosters. Are we going to see boosters becoming part of requirements, whether it's governmental standards or employer standards? I know I've seen some of my private employers implement booster mandates for their employees. Do we expect to see that happen? And then, secondarily, with the sort of confusion around this particular vaccine, and confusion between government action and private employer action, can private employers do this even if ETS is not in place? So those are the two sort of outstanding questions. And, Peter, maybe I'll start with you, and then Mike and Carol, if each of you have 20 seconds you want to respond.
In terms of boosters, I have no idea, no comment. That's really something that's beyond OSHA to make that determination. That I think would be something that would probably be coming from the CDC or another part of the government. We would be following along with whatever it is that they determine with respect to that.
Okay, meaning the definition of fully vaccinated might at some point include booster. Okay.
That would not be something that would be coming from us.
Yes, right. And yes. Yes,
yes and yes.
Yes and yes. I think the CDC is certainly talking about it already. I know that there are states out there that are talking about it. There is a likelihood that they will include booster in the definition of fully vaccinated. And also, yes, companies I think are going to be starting to do that if they haven't already.
And Carol, that's okay from?
And I would say yes and yes also. Employers can go ahead and require the vaccine as long as they protect the legal rights to religious accommodation and disability accommodation. And what that, reasonable accommodation for disability is, you don't have a direct threat defense unless you offer accommodation, and that means considering all the alternatives to accommodation.
Well, we are at the top of the hour. I could talk to you guys forever. I so much appreciate you coming to speak to our chapter of the Federal Bar Association here in Chicago. You guys are terrific. I probably will be reaching out to each one of you after this, so thank you for your time. I encourage our participants to stick around. We have another hour today and then 2 more hours tomorrow. We have, our next program is employee benefits for non-employee lawyers. And let me make sure I have that title right. Yes, employee benefits for non-benefits lawyers, and Todd Church from Littler Mendelson will be moderating that program. Thank you, everybody.
Thank you.
Thank you.
Thanks, Anna. Good afternoon, everyone. Just give us a minute. I'll let my panelists join. Great. Well, as Anna said, my name is Todd Church. I am the moderator for our next panel, which is employee benefits issues for non-benefits attorneys. Real quickly before we start, as Brenda mentioned at the outset of the program, please do submit any questions that you have through the chat function. The questions will make their way to me. We will definitely leave some time at the end of the program for questions, so please go ahead and send those. And in terms of CLE credit, anyone that wants CLE credit for the program is going to need the CLE code, which I have, and which I will read during the program. I'll make sure everyone is aware when I'm going to be reading it, so please stay tuned. Make sure you take down the CLE code so that you can get credit. We are very fortunate today to have a panel of 3 outstanding benefits attorneys. First, we have Martina Sherman. Martina is a shareholder at Dubofsky, Sherman, Cassiari, and Reynolds, PC, where she practices employment benefits. She has been named a rising star by Super Lawyer multiple years, I believe every year since 2016. Next panelist is Ruben Chapa. Ruben is ERISA counsel with the United States Department of Labor, Office of the Solicitor. He is one of only 7 regional ERISA counsel throughout the country. And Ruben is former president of the Hispanic Lawyers Association of Illinois. Finally, we have Stephanie Vasconcelos. Stephanie is a partner at Mayer Brown LLP. She works in their employment and benefits practice. And Stephanie also has been named a rising star by Super Lawyer for many, many years. So welcome to all of you. Again, my name is Todd Church. I'm a shareholder at Littler Mendelson PC here in Chicago. And although I'm the moderator for this panel, I'm actually very much part of the target audience because I am a non-benefits lawyer and I know very little about employee benefits. And I think one way to start would be, I think practitioners in other areas maybe think of labor and employment as this general monolith of you're an employment lawyer without necessarily appreciating that someone who does traditional labor versus someone who does wage and hour class action work versus someone who does trade secret and restrictive covenant law may have very different skill sets and practices. And I think we make the same mistake when it comes to benefits lawyers. We think you do employee benefits, so you do everything. And I know that's not the case. I know that practice varies widely, and that's evidenced by the 3 of you who have unique practices. So I was hoping maybe you could just take a minute. We can start with Martina and tell me a little bit about kind of your specific practice and what you do.
Sure. Well, thank you. Thanks for having me. My practice consists primarily of representing individuals in benefit claims. And so that would be suits for benefits under ERISA Section 502A1B. Most of my clients are pursuing disability benefits. We also do some health benefit claims and litigation, life insurance, some pension. So that's my practice.
Great, thank you. Stephanie, how about you?
Sure. I represent mostly employers and companies. I do a lot of day-to-day compliance work, whether it's working on, adopting or amending or terminating retirement plans, health plans, executive comp arrangements, and then things like offer letters, employment agreements, severance arrangements, that type of stuff. And then I also do a large part of my practice is M&A related work. So anytime we see M&A transactions, I help handle all benefits issues that arise on the transactions, whether it's, diligence and schedules, negotiating employee covenants, putting in place new employment arrangements, or analyzing existing exec comp arrangements, that type of thing. So kind of a benefits practice within an M&A deal.
And Ruben, could you tell us a bit about your practice?
Certainly. Good afternoon. So what we do, so there's 3 entities or agencies that enforce ERISA, and one of them is IRS, which I'm sure you're all aware of. Another is Department of Labor, which is who I work with, or for, I should say. And the third is PBGC, Pension Benefit Guarantee Corporation. PBGC only deals with, and it's a quasi-government entity, it only deals with defined benefit plans. Department of Labor, which is what I do, is we enforce the statute. And what we do is basically focus on the section of ERISA, which is on fiduciary responsibilities and certain fiduciary violations. For example, prohibited transactions and other things such as Part 7, which is discrimination in health plans. What happens with me particularly is that there's a misperception with people who deal with Department of Labor who think that we bring actions on behalf of the plan. We don't. We bring actions to enforce the law. And that is, if you don't remember anything else I say, which is quite possible, a good source for you is to go to our website, Department of Labor, in my website specifically, the Office of Solicitor, which is the attorneys that enforce the statutes promulgated by Congress to protect the American worker. And you look at our website, and there's a section that talks about briefs that we filed. And these briefs have been filed in several different settings, because really what we're trying to do is make certain, even if we're not directly in the case, bringing the case, we file a number of amicus briefs. There's many instances you'll see the court misunderstanding the statute. And our goal is to get the court to understand and to adjudicate it properly, meaning we're not on any one side. And again, the common misperception, people think that we're always pro-employer, pro-employee or pro-union. We're not. We're only enforcing the statute. So there are instances where we'll identify for the court that the proper interpretation may be to the benefit of an employer. Again, we're not trying to side one way or the other. We're simply saying this is the proper interpretation. So like I said, if you don't remember anything else, remember to look at that. That's a really good way of understanding what our position is. And given that we've been at the forefront of this since the beginning, we have some pretty good insight as to what's going on.
Thank you, Ruben. So let's start with talking about maybe some issue spotting, potential pitfalls. You may be thinking, I'm not a benefits lawyer, so why do I have to worry about benefits? That's not where I practice. And so I think that the point that we're going to make is that there are some issues that may pop up in your general practice or particularly a general employment law practice that implicate benefits issues that you may not even be aware of. So Martina, I guess I'd like to start with you. ERISA is obviously the statute that comes to mind when everyone thinks of benefits. Other than having a vague notion that it establishes some minimum standards for retirement and health plans, what can you tell us about ERISA, what it does, and really kind of how you recognize an ERISA plan when you see one and why that's important?
Sure. Well, I think sometimes it can be helpful to have a little bit of historical context with ERISA, and it's now almost 50 years old. So it's there's a lot of history, but it was enacted in 1974 after 10 years of congressional study, and the impetus for ERISA's enactment was the Studebaker pension plan collapse in 1963, and lots of pensioners going without pensions that they were promised as a result of this patchwork system of state law. And so Congress enacted ERISA to basically treat employers as trustees and impose upon them fiduciary duties of loyalty and care, and require that pension benefits be held in trust and subject to vesting schedules such that they could not be divested upon vestiture. ERISA established the Pension Benefit Guarantee Corporation, which Ruben mentioned as being kind of like the FDIC for pension plans, defined benefit pension plans. At the last minute, I think this is significant. ERISA was amended to include welfare benefit plans, so health insurance, life insurance, really any unfunded benefit that you would receive through your employer, either through funded through their general assets or through an insurance policy, but not through trust. And there's a lot of tension that you see in the ERISA case law because it's trying to do so many things at once. It's got aspects of trust law, contract law, administrative law, and sometimes those areas and even equitable remedies. And so sometimes those things come to tension, and that's where you see a lot of the case law is courts grappling with that. And my law partner, Mark Dubofsky, likes to call it the worst menu of all of those things because of just, well, I don't have time to go into it today, but back to your point of what are some concrete takeaways that practitioners, that we want non-benefits lawyers to know coming out of today's presentation. I think that if you leave this presentation with remembering nothing else, it's that ERISA has some of the strictest deadlines and sort of statutes of limitation for benefit claims of any employment law statute. So much like in an EEO claim or discrimination claim, you have 180 days to 300 days to file a charge of discrimination. In a benefit claim under ERISA, you have 60 to 180 days to appeal a denial of benefits. And if you don't appeal, then you can't later file a lawsuit. And so that's huge. And I practiced employment law a little bit myself, and I know that these things do arise where a client will come to you with a question of, oh, I got this denial letter, what do I do? Do you do this type of law? And it's just know that it's a ticking time bomb and that they need to appeal, or their right to file a lawsuit is forfeited. And then of course there are so many implications of a case being subject to ERISA from venue. ERISA has venue requirements, and most cases can only be brought in federal court. There's no jury trials. Discovery can be very limited, and remedies are also very limited because of ERISA's broad preemption provisions. So with that, I want to talk for a minute about how to recognize whether you're dealing with an ERISA plan. And I think the safest assumption is just assume that it is ERISA because of the statutes of limitations and the deadlines that I mentioned. But if you're dealing with a government plan, whether it's federal, state, municipal, it's pretty safe to assume that it's non-ERISA because ERISA doesn't apply to government plans. ERISA also doesn't apply to church plans, although unlike government plans, church plans can opt into ERISA. And church plans are defined very broadly to include really any entity with sort of a religious affiliation. So Advocate Healthcare, for instance, considers itself to have a church plan exempt from ERISA, but DePaul University while it's also a church plan, has opted into ERISA. The way that you would know if it's an ERISA plan is by requesting a copy of the plan document usually from the employer. You can also go to the DLL website and do a search for, it's called a Form 5500 that will usually only be filed if the plan is subjecting itself to ERISA. Another exemption to ERISA is something called a payroll practice. You see these a lot in short-term disability plans. The way that you can recognize a payroll practice is basically the benefits, the disability benefits are paid through payroll, as opposed to a separate check from an insurance company or from a trust. There's also individual policies. Oh, go ahead.
I was just going to add in one other thing. You sometimes see people style as a payroll practice as severance, and other people design their severance practices as an ERISA plan. So that's one that can go either way depending on how the program is structured, how much administration it requires, and it's a fairly complex question once you delve into it.
Yeah, absolutely. Severance plans are subject to ERISA, but whether something is or isn't a severance plan can be really kind of a murky or gray area. I was going to mention individual policies of insurance, like individual policies of disability insurance or life insurance, health insurance, are not subject to ERISA unless they're purchased from the employer, usually at a discount, and then the employer can inadvertently create something called a list bill, and some courts have interpreted that as creating an employee benefit plan. So something to be cautious of. The other thing I wanted to mention is stock options and employee incentive programs generally are not subject to ERISA. But some sorts of executive comp, many kinds of executive comp plans are, and that's not really my area, so I might kick it to Stephanie for really the expert opinion on this. But what I can say is that if you are dealing with some sort of executive comp arrangement, for instance, a client has come to you with a job offer and they want you to review it or negotiate on their behalf, just know that there are lots of potential ERISA issues that are implicated. You may be dealing with plans that are subject to ERISA, aren't subject to ERISA, or maybe certain parts are and others aren't, such as in the case, this is the case with the Top Hat plan. So really the best thing you can do in that circumstance is to call up a benefits lawyer and engage them, maybe on a consulting basis, to help you so that you don't inadvertently run afoul of ERISA. Although, Stephanie, maybe you can chime in on this. I think that as a plaintiff's lawyer, most of my clients, are concerned about, well, what is going to be the implication to me? And I would think that the implication in those cases where a plan is represented as non-ERISA and then it inadvertently becomes ERISA would mainly fall on the employer.
Yeah, I think that's right. So the Top Hat plan idea is if a plan is designed as something that is intended to provide substantial benefits in the way of retirement, it may be subject to ERISA. And that could include even kind of a bonus or long-term incentive plan might be considered to provide substantial retirement benefits, depending on the type of provisions in it. Or a non-qualified deferred comp plan may provide some substantial retirement type benefits. And in those cases, you may have what's called a Top Hat plan, which is an unfunded plan that's primarily designed to provide benefits to a select group of highly compensated employees. Those types of plans are subject to some components of ERISA and not other components. So they're not subject to the minimum participation and vesting rules. They're not subject to funding rules. They're not subject to the fiduciary responsibility requirements. They are subject to the claims and appeals timelines that Martina was talking about earlier. They are subject to reporting requirements, but they're much more limited. Instead of filing the Form 5500 that Martina mentioned, they file a single Top Hat exemption when the plan is put into place. So again, I think this is one of those situations where it's probably too much to go into a lot of detail on these, but there are different types of ERISA plan and different kind of levels of what can be an ERISA plan, and it's something to be aware of when you're entering into these arrangements.
And just to go back to what I was saying about how what would be the implications for the employee in this context, I could imagine a situation where an employee is offered some sort of executive comp plan, doesn't realize it's subject to ERISA, fails to timely appeal a denial, and then is pled out of court, basically. So there are concerns for plaintiffs as well.
Yeah, I think there could be concerns on either side of the equation if they fail to identify that.
Got it. Stephanie, one thing Martina mentioned, and just practically speaking, for practitioners, it sounds like where these things may come up would be in an offer letter / employment agreement, or in a separation severance agreement. What are some of the kind of key things to be aware of if you're preparing one of those agreements? Hey, here are provisions that should kind of perk up your antenna that there may be ERISA issues here that to be aware of.
Yeah, and Martina, I'm sure that you and I look at different things given the people that we represent. But I'll say when I look at an employment agreement, there are several things that I'm checking for benefits issues. And of course, I'm reading the whole thing and other things may come up. But one of the first provisions I look at is, are we promising any specific, health, welfare, retirement type benefits? And if so, does the provision include that, what we're saying in here is subject to the terms and conditions of the plan, it's subject to the eligibility terms and conditions of the plan, and that the company has the flexibility to change those things from time to time, because you don't want to later discover, at least on the company end, that you've promised some sort of level of benefit to somebody that you're actually not able to maintain long term, or that, you wouldn't want to tie up your 401k, your defined benefit pension plan, or your healthcare program within a single employment agreement or a single offer letter. So I usually check the benefits provision to make sure that it includes some flexibility there. If an employment agreement includes reimbursement language, like reimbursement for business expenses, moving expenses, anything else, I check to make sure that it is either 409A compliance, and I can talk about 409A in a minute, or that it defers to a company reimbursement policy that is itself 409A compliant. On bonuses, if the agreement includes any right to regular bonuses, I check to see whether the payment timing is, again, 409A compliant, or it defers to a plan that is 409A compliant. And after I get to the end of my list of things I check, we can talk about 409A.
We can circle back to that for sure.
And then I spend a lot of time looking at the severance provisions. So if an agreement has any severance provisions, I'm looking at what are the rights in the severance provisions. Can anyone control the payment timing based on their actions? So could, the executive or employee defer severance by holding the release and saying, I'm waiting to sign this until next year because I'd really prefer to be taxed next year? Or is there a good reason trigger in the agreement that is so flexible, like I can terminate if I want for good reason because you moved my office or my parking spot or you changed the lunch menu, such that it's, a hair trigger, so that I could really terminate at any time and choose to get my severance. Those can also raise issues under 409A. So those are some of the big issues I look at in employment agreements. Martina, do you have others before I kind of jump into maybe a few minutes on 409A and why I look for it?
And actually, Martina, Stephanie, Martina, go ahead, and then I want to circle back to Ruben on a couple more things before we jump into 409A.
Sure.
Okay.
I was just going to say, most of my clients come to me after they've been denied some sort of benefit. And so I'm not typically involved, on the front end with negotiating employment agreements. And I have the, good sense to retain counsel when I negotiate my own employment agreement. So I have referrals for anyone who is listening to this, program and represents executives, but maybe doesn't feel comfortable negotiating the executive comp piece for lawyers in the city who will represent individuals in those negotiations.
So, Ruben, before we kind of get away from ERISA, you had touched on earlier in your remarks the idea of sort of who are the ERISA enforcers. And I think unlike, you think of Title VII as an example, you have the EEOC and then you have private action. Someone can file a lawsuit. ERISA seems to be a little unique and different in that you have multiple actors that are enforcing it. And so if you could just kind of expand on that a little bit so people are aware of how they may come into contact with kind of several different entities.
Certainly. So In ERISA, you also have the ability, as we have identified earlier, that a private litigant can actually bring an action. That's all of this is found under Section 502, and it identifies who has the authority to bring an action. With respect to, so you can have a plan participant bring an action, you can have fiduciary on behalf of a plan bring an action, you can have Department of Labor bring an action, you can have PBGC bring an action, you can have IRS bring an action. One thing I did want to expand on and mention, though, is that, again, the thought process with one of the biggest things you really need to understand about ERISA, and Martina touched on it a moment ago, was that the underpinnings of ERISA is trust law. So one fallback you'll see a lot of times is the court going back to the whole concept that you hear what the way ERISA was really developed was essentially to deal with money that's under trust. And you think back, part of the rationale was because, as Martina mentioned, the Studebaker problem, that basically they were using the money to capitalize the business. And you saw this at the turn of the century, last century, where you saw a lot of robber barons doing the same thing. All of a sudden you have, JP Morgan, not that this happened, but that, he uses a company's pension fund to capitalize a new venture. And Congress was aware of that, and they said, well, wait a minute here. So that person's supposed to be the trustee. That person who's acting on behalf of the plan is supposed to be safeguarding those monies, especially because back in the day, defined benefit plans were really the rage. That was really what was out there. And so that's why you have trust law as a really strong method of seeing what should happen. Now it becomes a little bit different with defined contribution plans, because defined contribution plans, you're not always going to have a trust. You should in a retirement setting, but like for instance, in a health plan setting, in many instances, you don't have a trust account. In all honesty, I think it's not a good idea. I think you're better off having a trust account to the extent you can, because it puts you in a much better position if you have to prove things. As attorneys, we're always very diligent and always wanting to try to dot the I's and cross the T's, because we know down the line it's going to come back to haunt us. If we have something to say, hey, all the money went into this account, all the money came out of the account, it's fairly easy to follow. When you start commingling money, that's when you have problems. That's when the IRS comes in. That's when the Department of Labor comes in. And just so you understand how I might get involved, it would be one of my investigators. It can come to us in a number of different ways. Another agency, like the SEC, which have called me and said, hey, by the way, were you aware of this? Or the U.S. Attorney's Office has called me from different locations, because I handle all the Midwest. And they'll tell me, are you aware of this? And then I'll have the investigators go out there and investigate, and they'll issue administrative subpoenas, and then they'll compile the information and get back to us. And if they can't resolve the matter with the employer or the breaching fiduciary, then it will happen that they will probably make a litigation referral to my office. I'll get that litigation referral. I will assign an attorney to review the referral and give me a recommendation. Then based on that recommendation, I'll make a determination along with my boss as to whether we think this is just and that we should bring the action because there's losses associated with it. And if that's the case, then it'd go up to the Department of Justice for approval. And then once we get approval, we file the action in the federal district court where there's jurisdiction, usually where either the plan or the defendants may or may not be, where the defendants may be. So that's how we would get involved. And that's why it's important you understand that there's a lot of individuals that can essentially come up against you. And one of the things that Martina also touched on earlier is statute of limitations. And that's the thing that in many instances people forget, because they're like, well, what about if I settle out with Department of Labor, what about everyone else? Most of the time, if we brought an action, we're usually on the back end of the action. So that means that if you settle out with us, more than likely what's going to happen is that everyone else is already statute barred, unless you have a tolling agreement, which you haven't told me about. So those are things you have to keep in mind when you start being concerned about how this is going to play out.
Great, thank you. All right, Stephanie, we mentioned 409A. That's a topic that I know I wanted to spend definitely some more time on. So tell us, what is it and what do we need to know about it?
Well, 409A is something we could spend a whole day on. So I'll try to not do that, but spend at least 5 or 10 minutes on it so you have an awareness of it. Like everything else, 409A is something that was implemented because of perceived abuses that were happening. This one was passed as part of the American Jobs Creation Act in 2004, and it was generally effective beginning on 1/1/2005. And it was implemented primarily as a result of issues with Enron and WorldCom and this perception that executives had too much control over and access to their deferred compensation. And that when they saw things going wrong, they were able to say, hey, I had previously agreed to take this money later. Actually, I want it right now. And they were able to jump way ahead in the priority line over other people. And that was seen as a bad thing, and 409A was the result. 409A can be very hard to comply with and maybe went a little too far in the other direction, because the general idea is that it applies to, unless an exception is there, it applies to all payments where you have a legally binding right in 1 year to compensation that is or could be paid in a later taxable year. So without an exception, it technically applies to your paycheck that you did the services right at the end of the December, and it's paid in January of the next year. 409A is drafted broadly enough so that it applies even to those circumstances. And the idea behind 409A is you either need to fit within an exemption, of which there are a couple that I'll flag here today that are the ones that you'll probably see most regularly in your practices. Or if you don't fit within an exception, you need to comply with the strict payment timing and form rules that are set forth in 409A. Because if you don't, the result is a significant additional tax on the individual who has the right to the payment. The payor, the company or the employer or whoever, you know, is the payor in the circumstance, is not generally the person who's responsible for a penalty if something goes wrong for 409A purposes. So it's in the interest of kind of everyone involved to make sure that the payment structure is right up front. And that's one of the things that I think can feel particularly unfair, is that an individual could set up an agreement. They may not know that something is wrong with it, and the company may be more sophisticated, but the individual is the one that would be penalized if it was written incorrectly or paid incorrectly. So the couple of exceptions to 409A that we typically rely on so that a plan or a program or arrangement is not subject to the rules of 409A. One is the short-term deferral exception. The short-term deferral exception is any amount that's paid no later than the 15th day of the third month following the later of the end of the service provider's taxable year, so the individual who's providing the services, the employee or the contractor, or the end of the service recipient's tax year, in which the amount was no longer subject to a substantial risk of forfeiture. So usually this is March 15th is the critical date. This is why you see a lot of bonus programs that are designed so that they're paid no later than March 15th following the year to which the services relate, or you know, kind of any other payment, a retention bonus, something or other. It will be paid by that March 15th date so that it's very clear it was a short-term deferral arrangement. And I think that's something that you'll look out for in your agreements. And anytime you see a payment right where somebody has a legally binding right to it in 1 year and it's paid in a future year, you need to either figure out yourself or work with benefits counsel to figure out, is this subject to 409A? And if so, how does it comply? Or is it exempt from 409A? And if so, which of the exemptions does it fall under? The second exemption that I think you probably work with most commonly is the separation pay exception. So there's an exception for amounts that are paid solely due to involuntary separations from service. The amount has to be limited in scope. It is based on either 2 times their annual rate of pay in a prior year, or 2 times the 401A 17 limit, which I think is $305,000 right now, so 610. The agreement has to provide for a certain limited time frame that everything's paid by no later than the second year in which they terminate. And you can stack these exceptions together too. So if you had amounts that were paid within the short-term deferral time period and then another amount that was paid after that that was clearly separation pay, you could add them together so that everything was exempt potentially. One thing to note, and one thing I mentioned earlier, is that if you have separation pay that's payable on a termination for good reason, you need to analyze that to see whether the separation can remain involuntary. Section 409A has a safe harbor definition of good reason that has a few events that are considered involuntary. You know, if you're required to move by more than 50 miles, I think it is, or, you know, material reductions in pay, certain other material changes, but it also includes a cure period, and it includes the individual terminating within a certain period following failure to cure. So you couldn't have, say, something bad happen, and then 3 years later you say, by the way, now I'm terminating because of that event that happened 3 years ago. So for somebody's good reason termination to fall within the separation pay exception, it's important to stay close to that 409A definition, or at least keep that in mind. Otherwise, if you do not, what you'll end up with is likely a payment that's subject to 409A, and then you have to make sure it's compliant with it. And that's not necessarily problematic. 409A says that you can pay deferred compensation on certain set payment events. And there are 6 of them. Yeah, 6 of them. Separation from service, a specified date. So if you said, I will pay you X dollars on January 1, 2027, that's fine. Disability is defined under 409A. Death, change in control is defined under 409A, or an unforeseeable emergency. But all of these have to be actually written down in the plan if you want to do it. And there are very limited abilities to change the timing of the payment or the form of the payment once you've written them down. So you couldn't say, hey, we're going to pay you on this termination, even if you voluntarily leave in 3 years, we will pay you this separation payment. And then when it comes to time, you say, actually, we don't want to do that. Let's spread your payment out over 3 years once you leave, and that'll help us, you know, enforce some restrictive, whatever it is. Your ability to change those payments, if it's actually deferred comp subject to 409A, is nil. It becomes an error for the individual. The company is required to report it on the W-2 or the 1099. So you lose a lot of flexibility once you have deferred compensation. And I think where we find that people get into trouble is they have set up a payment structure that they didn't realize was deferred comp in the first place, and then they modify it, or they set it up and they didn't actually put in a proper payment event and we have to fix it. So it's things like that is where we see the errors, is not an awareness that 409A applies, either at the outset or when they want to change the payment at a later date, and they can't. And I don't know, Ruben or Martina or Todd, whether you see that in your practice as well. But it's one of the most complex issues we see. And I think the biggest problem is that a lot of people, when they're doing agreements, just don't realize that this rule is out there, or that the consequences can be so bad, and that there are limited abilities to fix it.
Got it. So I'm gonna hit you up back to back now, Stephanie, before we move on. Real kind of briefly, I know that there can be some issues when you have special health arrangements, whether that's executive health plans, wellness programs. Kind of, can you give an overview of some of those issues that may pop up that people need to be aware of?
Yeah, so there are a couple of issues that I see with health arrangements that can be particularly problematic. One is an agreement to reimburse for individual health premiums. This can be, the Affordable Care Act put in a number of requirements for group health plans, including that they not have annual or lifetime limits, that they cover preventive health free of charge. I'm sure there are others that I'm not thinking of, but those are 3 key requirements under the Affordable Care Act. When a company agrees that it will reimburse an individual's health coverage, which I sometimes see, particularly with smaller companies, as part of offer letters, They may not have health plans, so they'll tell their employees, hey, we're just going to give you whatever you need. Give us your receipts, we'll pay for it. What they don't realize is that health reimbursement arrangement itself is a health plan. And the government has taken a position that that's not only a group health plan, but it then fails to comply with those requirements because you can't guarantee the individual policy is covering preventive health care free of charge. You have annual and lifetime limits because you're only telling them you'll reimburse the receipts you give them. And it's something you're required to self-report. There's, I believe, no statute of limitations unless you self-report it, because otherwise there's no form to start the statute of limitations running. And it's one of those things that I've seen smaller companies do with, I think, fairly good intentions, and not realize that it could create a large problem. There have, since the Affordable Care Act, been a couple of new developments in the health reimbursement space, one being individual coverage health reimbursement arrangements. So companies can implement these individual coverage health reimbursement arrangements, but that requires, documentation, non-discrimination, and really actually setting up a program to do this, as opposed to the offer letter that says, give us your receipts and we'll pay you. But I want to make clear that it's not impossible now to pay for some health premiums. You just have to do it in a way that complies with the requirements. And then the other thing I wanted to raise that I think is an issue that even amongst benefits practitioners we go back and forth about, but is reimbursements of COBRA subsidies, or just paying for people's COBRA after they've been terminated. Depending on who you're talking to and their point of view, I think the concern is that particularly for self-insured plans, that can be considered discriminatory unless you're really doing it for absolutely everyone who terminates employment. So we generally counsel employers, and I think you see more and more employers doing this, just providing a lump sum that the individual can use to pay for health insurance, but is not a direct subsidy to help avoid some of those discrimination issues.
That's Chris. I think that's a really key point, just because I know I see that in my practice. It's a separation agreement. Here's your severance pay, and oh, by the way, we'll pick up your COBRA premium for the next few months. If you do that for one person that's separated and not for another, that's potentially problematic, which is why the lump sum method may make sense. So I'd like to kind of turn a little bit to some hot topics recently. You can impress all of your benefits colleagues and friends by knowing these at your next cocktail party. So I know 401k and kind of defined contribution, benefit, excessive fees cases have been in the news. Ruben, maybe you can kind of walk us through. There was an Oracle settlement a couple of years ago involving excessive fees, and then there's a case that just was argued that came out of the Seventh Circuit that was just argued in the Supreme Court last month, the Northwestern case. If you could maybe walk us through that.
Yes, this has been going on probably for the last, I don't know, I guess 3 or 4 years at least. And the premise is excessive fees. It can be in a number of different ways. And the excessive fees go along the path of, if you have a plan, typically you're going to have the company who's a plan sponsor who's acting as a fiduciary, either directly being a named fiduciary saying company ABC is the trustee for the plan, or through one of the CEOs or one of the executive officers. They'll be named as the trustee of the plan. And depending on whether the trustee of the plan administrator, and let's say that the plan document actually identifies their responsibility for the administration of the plan, or to make certain that that it's properly run, or just by virtue of ERISA requiring that under 404A1A, they have to act for the exclusive benefit of the plan participants, including not paying unreasonable fees. So what happens a lot of times is the fees that are generated by service providers, such as the ASK custodians, are higher than what other plans are generating, other plans are paying. And so the question becomes either it's that way, either the fees are higher, or the plan, the menu in the plan is higher. In other words, they're getting a product that's really not that great of a product, but they're paying an exorbitant sum. And sometimes what you see, and this makes it, when you see it this blatant, then it's really going to be a tough case for the defense to try to argue. Well, you see, for instance, there's a quid pro quo. In other words, the plan sponsor gets something out of that asset custodian because maybe they're doing banking at the same location. Maybe they say, you know what, I'm willing to incur that higher fee on one side of this, in other words, the plan side, as long as you're going to give me, what an interest-free loan for my business at, $100,000 a year. And those are easy. The court's going to say, wait a minute, what's going on? That's kind of unusual. So what's been happening more and more is you've seen a lot of different plans be exposed to this litigation. And most recently, as Todd had mentioned, there's a case in the Supreme Court right now, which is the Northwestern case, and oral arguments were had, I think beginning of December or late November. And it was interesting to see what the justices were thinking by the questions they had asked and the analysis that was done afterwards. There's this trend, and this is typical, I think, across the board in ERISA cases, that defense wants an easy way out. They say there's a lot of frivolous cases being filed. We don't think we should be dealing with this. This is just nuisance. And so they say that you should be able to give us some type of standard that allows us to get a motion to dismiss out quickly, show that it's a frivolous matter, and get rid of the case. And plaintiffs are saying, well, not so fast. There's some legitimate arguments. We need some discovery where these issues are going on. There's a reason why, again, underpinnings of ERISA trust law. There's a reason why the trustees have to act prudently, straight out in the standard. And again, being an ERISA nerd, I'll tell you, there's some really interesting case law out there, and I'll tell you that Supreme Court has gone through, in my belief, in the last 2 decades, more ERISA cases on average almost every year than they will in almost any other setting. So, and there's a reason for that. It's difficult. The statute is difficult, but it's also broad and far-reaching, as was mentioned earlier. So you sit there and you say, all right, prudence, for example, the Dudenhofer set of cases, where what would happen, and at some good success initially by the defense side, defense said that, there should be this presumption of prudence in an ESOP, employee stock ownership plan. Because the ESOP has to buy, because the plan sponsor has to buy shares of the company, they should get a presumption of prudence. And I think they wanted about 3 or 4 circuits, and each circuit, Department of Labor filed amicus briefs arguing against that, saying there's no such thing. The statute is absolutely clear. There's only one set of prudence. It's found in ERISA section 404A1B. And it simply says that the fiduciary has to act prudently. And up until we got into the Supreme Court, we lost in every instance. However, we went to the Supreme Court, we argued our position, and we prevailed. So that's the kind of thing that's out there right now, and it is cutting edge issue. And you've seen a lot of actions being brought against a lot of different entities. And when I say Northwestern, we're talking about the university, Northwestern University. So.
And Martina, I know another kind of topic that's been out there and that potentially could be headed to the Supreme Court is arbitrability of ERISA claims. There was a case in the Second Circuit in the spring of 2021, the Cooper case, and then a recent case here in the Seventh Circuit in, I believe, September, the Schmidt case, dealing with arbitration clauses. If you could talk a little bit about the issues in those cases.
Sure, and I read the Smith case prior to this presentation. I'm familiar with the Duran case in the Ninth Circuit. I think the important thing to know is that all of the circuit courts of appeal that have considered this issue have ruled that ERISA claims generally are arbitrable. And with the exception of disability and health claims, which under the ERISA claims regs are actually, you can't bind claimants in a disability or health claim to arbitration. But outside of that, pension, certainly in the 401k space, the claims are arbitrable. And but nonetheless, courts have come down, at least the Ninth Circuit and the Seventh Circuit came down in favor of the plaintiffs in those cases, ruling that the specific claims were not subject to the binding arbitration, the class waivers in these employment agreements that the claimants had signed. The cases, and I think, I don't recall what the Second Circuit ruled in the Cooper case. Does anyone else can someone chime in and say whether it was deemed to be arbitrable or not?
My recollection is that they found that it was not arbitrable, but not that ERISA generally was not. It was just not that particular provision.
Yeah, with what I'm finding to be interesting in these cases is that you're not finding a lot of bright line rules. You're seeing that the courts are really having to sort of dig into the weeds and the facts of each specific case and look at things like consideration. Was there consideration for this contract or this employment agreement, this provision that was added after the specific plan participant who brought the claim retired? Or another issue that's come up that's kind of interesting is sort of like, I guess for lack of a better word, a preemption issue, which is, ERISA has an express preemption clause, but then it also has, I guess it's called conflict preemption, where, state statutes and other contracts cannot interfere with ERISA's express remedial provisions. And so the Schmidt case from the Seventh Circuit ruled that the specific arbitration provisions in that agreement were in conflict with ERISA's remedies because, among other things, they would not have allowed the plaintiff in the Schmidt case to obtain the remedy that they were seeking, which was removal of the plan administrator in that case, which is an equitable remedy. And so that provision was struck down as unenforceable. So the Supreme Court in general has been taking up a lot of arbitration cases, and I'm curious to see. I don't know that the issue is ripe yet to make it to the Supreme Court because the cases themselves that have made it up to the circuit court level are so fact specific. At least that's my impression.
Ruben, I don't know, did you have any thoughts on that? You want to weigh in at all?
Another thing I would touch on is that I don't think that this would prevent an agency like the IRS or DOL or PBGC from bringing an action. I think that we'd be outside of that purview. So in other words, just because there's an arbitration provision in there, you can't contract out of the law. And then I've seen that argument be made in so many different type of settings, and it typically doesn't work. Well, it's never worked as far as I can tell.
And the other thing that's interesting is that you see in these cases, some of them are actually, the employers have these arbitration clauses, mandatory arbitration and class waivers, and then they're trying to get out of it because the individual employees are bringing hundreds of arbitrations in some cases. And so they're forcing the employer to litigate the same issue hundreds of times and paying excessive attorney's fees in the process. And so I've seen cases where they argue for the enforcement of the arbitration clause, and then they argue against the enforcement, and most of the courts will not allow them to have it both ways.
So we do have a few questions, but before I turn to the questions, I'm going to give out the CLE code. So kind of hopefully people's ears are perked up. Here is the CLE code that you'll all need to take down to get credit. It is 221001. Again, the CLE code that everyone's going to need is 221001. We have a few questions. The first, I think, is probably geared towards Stephanie, which is, how is stock vesting treated under 409A?
So stock vesting is not actually, if we're talking about restricted stock, that is covered under 83B rather than 409A. 409A will deal with things like restricted stock units. Options are exempt under 409A provided that they meet certain criteria, including that they were granted at fair market value as of the date of the grant. So that's another area where you can stumble into trouble if you granted discount options. But for restricted stock and their vesting, you'd actually need to look at 83B rather than 409A.
Great, thank you. Here we have it. People are very curious about 409A. The question is, can you please elaborate as to whether there is interplay between 409A and the Illinois Wage Payment and Collection Act for failure to pay earned bonuses or commissions?
I'm not sure that there's a direct interplay between the two of them. 409A specifies, that you need to set forth payment timing and form of future wages, bonuses, commission, and I imagine that the IWPCA does as well, though I defer to my employment attorney colleagues on that one. So that's one where we often talk to each other. I think an area where we often have I can see a difference and where we often have hearty debates is I'll say, okay, we can pay this and say you have to stay employed through the payment date in March in order to get payment. And my employment colleague will tell me, no, that doesn't really work. If all the services were performed the year before, depending on the state, they may have earned that as of December 31st rather than the continuing employment requirement, which 409A would recognize as a substantial risk of forfeiture. The state wage payment laws may say, no, if the true performance was the calendar year prior, you may have earned that bonus already by December 31st, and it may not recognize the continuing employment requirement. So I'm not sure if I answered that properly, but that's where I think of the two as having a bit of interplay and maybe a difference in analysis.
Yeah, and what I'm wondering, maybe the question is, the Wage Payment and Collection Act has certain requirements, and there's a private right of action that a plaintiff can bring under that statute. My understanding of 409A is that it's an amendment to the Internal Revenue Code, and obviously, please correct me if I'm wrong, but there's an individual plaintiff isn't bringing a private right of action under 409A. Is that right?
Yeah, that's correct.
Okay. We have another question about what are remedies for Section 510 employee retaliation claims?
I can take that. They're similar, I think, to Title VII discrimination claims. So you can get front pay, back pay, compensatory damages. I don't know that there are punitives or statutory damages under ERISA, but otherwise similar to an employment action. And then obviously, 510 claim can be complex because the idea is that you're interfering with a benefit, and so terminating someone to interfere with the benefit, then the benefits that they were not able to obtain would also be the remedy.
I think that was it in terms of questions. Give me 1 second. I'm just double checking the chat to make sure there's nothing else there.
I guess one question I'd have on that, on the remedies on a 510 case, is I wonder how far you can take it, because I know under Cigna versus Amara, the Supreme Court decision, it did discuss a number of different remedies out there, but that was generally for ERISA violations. And 510 is a very, to me, unusual whistleblower provision based on the number of statutes I've seen, how they're set up. So I don't know if you can actually expand that into other areas like a surcharge remedy, but just a thought, just thinking out loud.
I think so. We are basically coming up right up against our time. First, I just want to say again, thank you so much, Ruben, Stephanie, Martina, for taking the time to join us on the panel. Really appreciate it. And I want to, for our participants, remind everybody, once again, I'll give the CLE code in case someone missed it. It's 221001. And we have the second part of our employment law seminar. The second part of this session is tomorrow, Tuesday, January 11th. It's another 2-hour session starting at 12 p.m. And we'll have 2 panels tomorrow. The first panel is about changing legal standards in discrimination cases. And then our second panel that starts at 1 p.m. will be our annual judges panel with our federal several district court and magistrate judges, which we know is always among our very most popular panels. So please join tomorrow, again, Tuesday, January 11th, starting at noon. Thank you all so much. I appreciate it. Everyone have a great rest of the afternoon. Thank you.